I am Adele Kimmel, and I am the director of the Student Civil Rights Project at Public Justice. It means that I'm the head of a special project that uses litigation and advocacy to combat harassment and other forms of discrimination so students can learn and thrive in school.
Let's start off with how you became involved with public justice. What led you there?
Yes, about a year before I came to Public Justice in 1993, a very close college friend of mine died of breast cancer. And it led me to question many things, one of which was, what do I want to do with my legal career? I had always known when I was in law school that I wanted to do public interest law. And because I had student loans to pay off, I ended up working for a small law firm that did civil litigation. And when my good friend died, it made me think, I need to go back and do what I intended to do when I was in law school. Why did I become a lawyer? Because I wanted to do public service. And a good friend of mine told me about public justice. And when I read the job announcement and saw that one of the requirements was that you had to have a healthy sense of outrage, I thought, well, I've got that in abundance. And when I came to interview at Public Justice, I was told that I would have the freedom to build out a civil rights practice at Public Justice, which is what I had wanted to do. There wasn't much civil rights work being done at Public Justice at the time, and I was given the flexibility to build the practice the way I would like to see it. So that was very appealing to me, and it was going to enable me to do what I always wanted to do, which was to make a difference in the world and to bring more justice to the world. So that's how I came to Public Justice. No, I was in Washington, D.C. already, and so I stayed in Washington, D.C. What I did have to do, though, was take a big pay cut. I went to the University of Virginia, undergrad and law school. When I came to Public Justice in 1994, it was very different than it is today. It was quite small. I was one of two staff attorneys. We now have over 20 attorneys. There was, the attorney meetings were the executive director and myself and Leslie Bruckner, and that was it. So it was quite small, and just the way we did things was quite different back then than the way we do things now. So for example, back then, we would take any case that passed the damn outrage test. It wasn't especially strategic. I mean, we were really focused on impact litigation, but it was any case that passed the damn outrage test. And now we are much more strategic. And litigation, while it's still our primary tool, is one of many tools that we use to make change. So I feel like we have a much greater impact now than we did when I started 27 years ago. So one thing that we do very effectively, that we did some back in the day when I first started, was to use the media to get attention to our cases. We use the media much more. And then on top of that, we use community organizing so that the people that we're representing, and in my area, it's most often students, can use their voices and become advocates for change themselves. And so they really become empowered to help make sure that the change we make lasts. We do outreach, we do education, we do advocacy with media, with other groups, and then also sometimes legislatively, which is something we didn't do when I first started at Public Justice. So it's just, we have a lot more tools in our toolkit to make systemic change and make sure the change lasts. Oh, yes. And depending on what you mean by team, so I feel like all my colleagues are extremely supportive. And I also work with attorneys, usually plaintiff side attorneys in the cases. So that's part of the team. And then in-house for the Student Civil Rights Project, I have two attorneys working with me, a law fellow and a permanent staff attorney. The Student Civil Rights Project is something that I spearheaded starting about 7 years ago. It was under another name then. It was the Anti-Bullying Campaign, and then combined with our Gender and Sexual Violence program. But the idea behind it is to make sure that all students can learn and thrive in school and that they have equal access to education. And in particular, we've been focusing on barriers based on race and gender. All of the above. So we started out focusing on K through 12 public schools, but we also sue institutions of higher education. So we sue universities and colleges and public schools, sometimes private schools as well, that are depriving students of equal access to education based on discrimination or harassment. So a lot of the cases that we do involve students who have experienced sexual harassment, often sexual violence at school, and then they are sexually assaulted, and either the school could have prevented the sexual assault because they knew that the person who had harassed our client was a serial predator, or they didn't respond appropriately when they learned about the sexual assault and deprived the student of educational opportunities by essentially forcing them to continue to be in a hostile educational environment with their harasser. So we've had a lot of success in this area. We've represented many students who have experienced sexual violence by another student or by an employee of the school. And one way that we have made significant change is not only changing the law to make it easier for students to get justice in this area, but also by changing the culture of the school or the school district that we have sued. So things like changes to their harassment and discrimination policies and the procedures that they use when they're addressing harassment at school, changes to the way they train and educate the employees and administrators who have to address a report of sexual harassment, changes to training for students and education for students so they understand when something is sexual harassment and what they should and should not be doing, and who they report to when something happens, making sure that schools track when somebody reports that they have been sexually harassed. And so by doing these kind of systemic reforms, making systemic reforms within the schools, it makes it a safer, more welcoming place for students. I will add, Neville, that one other thing that we do for the students that we represent is, in addition to getting systemic change to the culture of the school, we get justice for the individual. So we're also getting them monetary damages on top of the reforms that they are seeking, because most of the clients we represent say that the reason that they are filing a lawsuit is they don't want any other student to experience what they experienced. And I'm not just talking about the harassment itself, but also the school's response to the harassment, the betrayal by the people in a position of authority who are supposed to protect the students and don't. And so these students are very motivated to make change within their schools so that no other student has to experience what they did. Most of our cases settle, like most cases generally, in the Title IX arena, which Title IX prohibits sex discrimination in education programs and activities that receive federal financial assistance. So it prohibits sex discrimination in all public schools and pretty much every private college and university, and public colleges and universities. And so Title IX litigation, I have been doing since I started public justice, focusing on harassment in particular for the last 7 years or so. And in that time, we have only gone to trial once. And even though we lost the one case we tried, we got it reversed on appeal because the judge gave bad instructions and ordered a new trial. And we're about to go to trial again in that case. Oh, I feel that we're definitely making progress. You know, sexual harassment at schools and the problem of sexual assault at schools just wasn't really on the radar of a lot of people until about 20 years ago. And then it finally, because of a lot of student activism, got on the radar of federal government officials. And the federal government started to issue more guidance about sexual violence at schools and what schools' obligations were to address it. And that's part of what led me to switch the Title IX work I was doing. Earlier, I had been focusing on Title IX in the athletics arena, and I had been representing women intercollegiate athletes whose teams had been eliminated from their universities, as well as coaches who had been retaliated against for complaining about gender inequities in their athletics program. And then as I saw, almost every day, I would read some story about a student who had been sexually assaulted either on or off campus and was subject to a hostile environment at school, and the schools weren't doing anything to address it. And it was hard to even watch a news program without seeing a story about this. And I thought, I think this is something public justice can do something about. And I took a look at the law, and it wasn't very well developed. The liability standards weren't very well developed. Some courts were interpreting liability quite narrowly, and I thought that there was a lot public justice could do to make sure that courts were interpreting Title IX as broadly as it was intended to be interpreted, and making sure that students could continue their education without having to contend with a hostile educational environment based on their sex. Mostly federal court. The claims that we bring are federal civil rights claims. And I know up till now we've been talking about the Title IX work that I've been doing at Public Justice, but we also have been doing work under Title VI, which is sort of a sister statute that prohibits race discrimination, discrimination based on race, national origin, and color at schools that receive federal funds. And one of the early cases, actually, that I brought while I was at Public Justice was a case called Curitin versus National Collegiate Athletic Association. This was in the late 1990s, and we sued the NCAA for on behalf of Black student athletes who had been denied the opportunity to get athletic scholarships because they did not meet the NCAA's what's called their freshman eligibility requirements. They had to get a minimum test score, a minimum score on standardized test to be eligible to receive an athletic scholarship. And for many Black student athletes, the athletic scholarship was really a pathway to getting an education at a college or university. And even students with fantastic grades, like straight A students, if they didn't get that minimum test score on an ACT or an SAT, they couldn't get a scholarship to college or university. And so we had sued the NCAA under Title VI because at the time it had a youth sports program that received federal money, which made the NCAA subject to these kinds of lawsuits. And this is one of my more memorable cases early on. We had won on behalf of the student plaintiffs we represented. We had won on summary judgment, which is very rare for plaintiffs. Plaintiffs rarely move for summary judgment in comparison to defendants, and we won on summary judgment. Unfortunately, the Court of Appeals reversed on a technical jurisdictional ground, but because we had another tool in our toolkit, we had done so much publicity on how unjust and discriminatory the NCAA's initial eligibility rule was, they got rid of it anyway. Even though they weren't forced to ultimately by our lawsuit, they were forced to because of all the bad publicity the lawsuit garnered. So we won just in a different way. And it's because we had a backup plan, basically.
Talk about the quality of lawyering that you're up against.
It varies. These cases are generally quite challenging for a number of reasons. Very often, the school hires a private law firm to represent it in the litigation. This is, I mean, when we sue a university, if it's a state university, then it is, a government entity that's involved. But when we're suing most of the time when we sue a school district, we are dealing with private counsel and then often also an insurance adjuster who is calling the shots. And go ahead, Neville. Both. These cases are driven both by facts and law. There are certain types of legal defenses that we see over and over again. So, for example, one thing that we are running into quite often now is that school districts will try to defend a case where a student was sexually assaulted one time by saying that they don't have any responsibility under Title IX to address the sexual harassment unless the student was sexually assaulted a second time. Basically, it's the one free rape rule. And they're making this argument over and over and over again, trying to escape liability because the student wasn't sexually assaulted a second time after reporting. And so this is something that so far we've been successfully battling, saying, no, there's no one free rape rule. if you do not address the hostile educational environment that occurs after the sexual assault and take steps to ensure that this student can get his or her education safely in a welcoming environment after reporting the sexual assault, then you are on the hook and you need to take care of that. I would like to tell you that there's an area of the country where school districts are doing a really good job in handling racial harassment and sexual harassment, but I have not found a school district that I think really does a good job yet. There are some places where it's worse than others. So school districts that get less funding and just don't have the money available to, for example, have the required Title IX coordinator and have the training that they should have to make sure that the Title IX coordinator and others understand what their job responsibilities are, and that also students understand what they can and can't do and who they're supposed to go to. Schools that have less money often do a worse job. We are very strategic about the cases that we take in the Student Civil Rights Project. We are looking to see if any of the cases involve a gender justice or racial justice issue. And by gender justice, I'm not just talking about sexual assault. I'm also talking about issues involving harassment of LGBTQ students. And it also might not be sexual assault. It could be something like dating violence that doesn't actually involve sexual assault. So we're looking at a variety of forms of gender justice issues. And then also on the race front, we're looking at not just harassment, but is there discriminatory discipline? Are Black students being disciplined far more frequently than white students, and for things that white students don't get in trouble for, like dress code violations or something like that? So we're looking at discriminatory discipline and racial harassment and various forms of gender-based discrimination. And we're also looking to see if any of these cases involve an area of law that is still in flux, and we're trying to make sure it's developed appropriately. So like the further harassment issue that I was talking about before, making sure that courts don't interpret the law so narrowly that there is a one free rape rule. And also that, for example, we're looking for cases where courts will understand that dating violence is in fact gender-based harassment. It's not just based on some interpersonal dispute, that very often a reason that say, an intimate partner abuses his or her partner has to do with gender-based stereotypes. The cases come from a combination of sources. Sometimes it is just a layperson who writes to us or calls us, and we end up taking some of those cases, but more often it's from another attorney who either doesn't litigate these kinds of cases, doesn't do it often, or doesn't do any litigation. It could be a public interest group that doesn't do litigation. And so for example, it might be a group that we have a relationship with that does advocacy in this space, like Know Your Nine, for example, might say, hey, can you help this student survivor out? We don't litigate, and we heard about this, and maybe you can help this person out. Let me mention one other source of our cases, and then I'll get into that. So one other source of our cases is that we proactively reach out to attorneys based on following what cases have been filed and decided. And so sometimes we'll see, for example, that an attorney litigated a Title IX or a Title VI case, and they got a bad decision on an issue that's still a legal issue that's being developed in the courts and hasn't really been decided one way or the other yet. And we'll reach out and say, hey, would you like us to come in and help you either amend your complaint or handle an appeal in your case? And so that's another way that we're actively trying to shape the law in a positive way. And then in terms of how we get approval to take cases, we have a committee, the Case Evaluation Committee, that will look at all the cases that we recommend. We will write a memo and lay out who we'd be representing and who we'd be working with in terms of co-counsel and what the financial arrangements would be. And we have to get approval from our Case Evaluation Committee before we can take on any case. Yes, so all of these civil rights cases that we're bringing under federal law are fee shifting cases, which means that if we win, the defendant has to pay our fees. So pretty much all the work that we do in the Student Civil Rights Project involves the payment of fees by the wrongdoer. So if we win, we get paid. I don't have one favorite, but there are definitely a few that really have stood out over the years. Sometimes because of the result, sometimes because of certain events that happened, and sometimes because of who I've gotten to work with. And so one thing you asked about earlier, Neville, was the teams that we put together to work on cases. And we often work with other members of public justice, sometimes board members, but we work with attorneys who are typically plaintiff side attorneys, almost always. And those who aren't members of public justice when the case started usually become members after they work with us. And one case that stands out for me in particular is a case that I worked on with board member Linda Correa, and it's called Flood versus Florida Gulf Coast University. And this was the first case I got to work on with Linda. We've done many since, but this case involved a really successful volleyball coach, Jay Flood, at Florida Gulf Coast University, who spoke up about gender inequities in her school's sports program. And when she did so, the school retaliated against her and fired her. And another coach, a golf coach, Holly Vaughn, ended up joining the case. She quit after voicing her concerns about gender inequities in the school's athletic program, and was essentially constructively discharged. And so we represented these two coaches. And what was so memorable about this case in particular was mediating with Linda Correa. And during the course of the mediation, this was in Fort Myers, Florida, the mediator pulled Linda and me out into the hallway, out of earshot of our clients, because he thought that our settlement demand was too high. And he thought we were being unreasonable. And at one point, he said to us, "Do you understand what part of the world you're in? Here, we get $1 million in a dead baby case." And Linda, without batting an eye, calmly responded and said, "We're here to change your world." And that, to me, is emblematic of what public justice does. We're here to change the world. We're here to bring more justice to the world. And that case is so memorable because of that particular moment. And despite the mediator telling us we were asking for too much, what we ended up getting in that case was $3.4 million for the two coaches, and systemic reform in the form of 5 years of monitoring by an outside Title IX expert to make sure that the university was in full compliance with Title IX. So it was a great result, both individually for the clients and to change what was happening at the school. And I will say, as a result, again, of all the publicity and the work that we did on the case, the athletic director left after we settled the case. Absolutely. It is the most collegial place I have ever worked. I feel lucky every day to work with such brilliant and kind and compassionate colleagues.